Thank you very much. And so I guess some of you are still voting. So once again, welcome to our webinar, which, as it has been mentioned, is dedicated to home office and other threats in Russia. Actually, this topic could not be more actual, considering the recent activity of some state authorities and of the mayor of Moscow over the last few days. Indeed, due to the recent increase in the number of people infected with the coronavirus, the Ministry of Health has last Tuesday called on Russian companies actually to introduce a remote work mode where possible, and this in order to reduce social contacts between people. In addition to that, last Tuesday, it has been known that the mayor of Moscow sent letter to more than 5,000 major metropolitan companies recommending them to return employees to remote work. And this is in order to reduce the movement around the cities and for the good health and the safety of Moscovites. And finally, as maybe many of you certainly know, last Friday, the mayor of Moscow has signed a decree according to which Moscow employers are recommended, first of all, to send to remote work employees over 65 years old, as well as employees having chronic disease. It has been as well recommended to use internal acts or issue, internal acts to list the employees who can be put and sent to remote work. And generally speaking, it has been recommended to minimize the number of people which will be present in the office. And this is applicable starting from yesterday. These recommendations are not new, and they are just resuming the ones which were taken by various authorities in March, and especially by the Ministry of Labor, which on the 26th of March recommended employers to send as much as possible employees where, of course, it did not impair the good functioning of the company to remote work. And this followed the presidential decree of 25th of March, which described the period from 30th of March till 3rd of April as non-working days with preservation of salary, knowing that actually this period has been extended till 11th of May. So during this non-working days period, many employees of most of the companies, except the one which were entitled to work, resort to remote work. And after the 11th of May, when actually companies step by step have been entitled to resume their work in their offices or plant, actually many employers to conform with the instruction and the sanitary measures imposed by the Federal Service for Surveillance of Consumer Protection Rights and Human Well-being, continued actually to apply and resort to remote work. And in light of the recent recommendation, will start transferring or retransferring employees to remote work. What I'd like to mention as well is while actually distant work, the notion of distant work itself has been introduced in the Russian law in 2014, the notion of remote work, as we are all using it, has not been legalized yet, and there is no content on legal definition. Therefore, while sending people on remote work, currently employers have to rely on and comply with the recommendation which have been made by the Ministry of Labor to arrange for such a transfer. But of course, with the pandemic, the need to document this practice and to change labor standards have become obvious. And this is why in June this year, bill has been introduced in order to provide for remote work possibility. Actually, this bill has passed its first readings, which shows acceptance in its principle of this form of work, and is currently discussed before the Duma, the lower house in Russia, before being presented to its second reading. So during this seminar, and considering what I have just been saying, we will thus provide you with, first of all, an overview of distant work, which is defined by the law, versus remote work, which so far is not defined by the law, and the way both mode of work must be formalized. Then we will move on to the draft law regulating temporary remote work, about which I have just been talking. Then we will move to working safety obligation, workplace safety obligation, work discipline, and finally, we will end this webinar by reimbursement of expenses, both under distant work and remote work. So now I'm very pleased to leave the floor to my colleague Yekaterina Elekchen, and who will be giving you an overview of distant work versus remote work. Katya?
Yes, good afternoon, dear participants. Christoph, maybe you will announce results of the poll. Okay, so maybe we will do it a little bit later. So good afternoon, participants. Let's start with an overview of distant work versus remote work. You may be wondering why we call this while we distinguish these two terms, which are seemingly the same. Well, and indeed, substantially, this is the same arrangement. It's type of work when employee works outside of the employer's premises. Mostly, it's work from home. But in Russian law and practice, we have such a structure where these two types of working arrangement are different because of the following. Well, the distant work is regulated by labor code. There is a special paragraph on it, and all specifics of employment agreements on distant work, they are regulated by the labor code. Also, distant work is more or less and usually a permanent assignment arrangement. For example, if you have an employee, a sales representative in another region of Russia, or an IT specialist in another region who works always in outside of the employer's premises, this is usually formalized as distant work as per special article of the labor code. As for remote work, on the opposite to distant work, it is not directly envisaged by labor code. It is regulated by various letters of the Ministry of Labor that were issued this spring due to COVID-19 pandemic. And unfortunately, some clarifications in this letter, they are contradicting to each other, and employers had to navigate through this uncertain rules and regulations and establish their own rules of remote working by issuing internal orders or policies on such remote work. The remote work in Russian, I will name it in Russian for our Russian-speaking participants, it's удаленная работа. Remote work is considered as a temporary measure usually. Like, for example, we have now when employees were transferred to work from home due to pandemic, or some employers provide employees an opportunity to work remotely from home as an additional benefit. For example, 1 or 2 days per week they can work remotely, or for example, if employees have some special family situations, they can work remotely. As an opposite to distant work, remote work is temporary arrangement, and it's often a combination of office work and remote work. And such combination is not regulated by Russian labor code yet, And further in the webinar, we will describe what is planned to be implemented. We hope it will be done soon. So how to formalize distant and remote work? As distant work is regulated by the labor code, it is really straightforward. You just need to sign an employment agreement. It's a special type of employment agreement for distant work. Or if you transfer currently office-based employee to distant work, you sign an addendum to employment agreement. Of course, you need the consent of the employee for such hiring, or especially for transfer to distant work. One of the main advantages of the distant work regime is that you can sign documents with the employee using electronic signatures. Unfortunately, law requires using qualified, so-called qualified e-signature, which could be a little bit burdensome because both employer and the employee need to apply to a special provider and obtain token to use this signature. But once it is done, it is very convenient because you can exchange any HR documents in electronic format, no need to sign hard copies. One exception is the original of the employment agreement. Even if it's signed in electronic way, still employer should print it out, sign and send to employee by registered post within 5 days after execution of this agreement. The remote work, on the opposite, because it's not regulated by the labor code, it is usually regulated by internal policies and orders of the employer. For example, when we had the pandemic, many employers issued orders to employees to work remotely from certain day, and they did not formalize this in employment contracts. Unfortunately, labor authorities also did not clarify whether it is mandatory to sign an addendum to employment contract in such situation or not. They were changing their mind like week after another week. That is why we would recommend to sign addendum to employment contracts with employees, because this is more safe approach, because in case you don't do that, and then the Ministry of Labor decides that the employment or addendum to employment contract was required, there could be potentially administrative fine for that. Also, to transfer employees to remote work, of course, you need the employee's consent. Even currently, even in a pandemic situation, if employee rejects to work from home, you cannot force him or her to do so. We advise to collect consents of employees in written form on addendum to employment agreement, or in the order of the employer on remote work, or in a separate document. It will help you to confirm that employee really agreed to this remote work. Also, in I think unprecedented approach used due to pandemic, the labor authorities allowed to execute documents related to transfer to remote work via scanned copies. Well, in normal circumstances, Russian labor law requires hard copy documents, and scanned copies normally just don't work. But in this case, they allowed to sign documents via scanned copies, but the labor authorities advised to exchange hard copy documents once you resume your normal operations. Now I pass word to Christoph, who will describe potential developments in distant work regime in Russia.
Thank you, Katia. Just before I start on this part, could we see, please, the result of the poll? So I have just a little, sorry. So yeah, from what I've seen, 16% of the attendees are back to the office, whereas 84% of you are still working from home. So most of us, we are still working from home, and if actually with Katia we are back to the office today and in our meeting room, actually as well for us as well, we are still working from home. And could I have as well results on the second poll, please? Okay, sorry, I'm just informed that this poll has just been launched today. So if I may kindly ask you just to fill in very quickly or to answer very quickly, then we will move on to this part on the draft law. Could we be back to the presentation, please? Sorry, I have the answer. So we have a lot of colleagues, 58% of lawyers, as well as HR specialists. Thank you. Thank you for your answers. Okay, so let's talk very briefly now about this draft law, which has been introduced to the Duma in June. So first of all, I'd like to mention that it has been proposed in the fall last year to introduce some amendments to the labor legislation and to provide for the possibility to send employees to temporary remote work. But actually, at this time, the Ministry of Labor has considered this change unnecessary. But of course, with the pandemic, the situation has changed, and the need to introduce in the Russian legislation the possibility to send employees to temporary remote work has become an evidence. At this stage, because as I said, the bill has just passed its first reading and is still under discussion and being amended. What are the main features of the draft law? First of all, both distant work and remote work will be defined under the same chapter, chapter 49 of the Russian Labor Code. And actually, these concepts will be merged into one terminology, distant, in brackets, remote work. This is to avoid any confusion. Then, besides the permanent distant work, which is already provided by the provisions of the Labor Code, this draft law introduced two more types of distant work. The one being temporary distant work, where it will be possible for the employer to send the employee to remote work for a specified period of time. And the second one being combination of office and distant work, where the employee actually will spend some days in the office and some days working from home. Another interesting feature, despite the fact that it has raised some question, and I will mention it, is that in case of natural or man-made disaster, industrial accident, fire, flood, earthquake, epidemic, episodic, and some exceptional cases, it will be possible for the employer to send his employees to temporary remote work according to a simplified procedure. Indeed, there will be no need to conclude an addendum to the current employment agreement. It will be possible to do so for the employer by passing a local normative act in which he will actually list the employees to be transferred to remote work and the procedure for organizing such a remote work mode. So that is very important, but what raised a lot of issues is that currently the draft law mentioned that the consent of the employees will be still necessary. So how will it work if, for example, due to specific circumstances, the employer has to send its employees to remote work for a certain period of time, if actually one of the employees doesn't accept this transfer. So far, this issue is still pending, and hopefully amendments will be made to the draft law to clarify this issue. Another important issue and feature of this draft law is that the enhanced qualified electronic signature is abandoned. What will be required is for the employer to provide in its local normative acts the method allowing to identify the sender in case of exchange of document, knowing that the receiver will have to confirm the safe receipt of these document upon their receipt. Another feature which is very important, and once again it is raising a lot of concern among the specialists, is the fact that the draft law actually deprive the employer to provide in the labor employment some additional ground for terminating the employment agreement. Currently, according to the provision on distant work, an employer can set in the employment agreement some additional ground to the one which are already provided for ordinary employees. For example, should an employee fail to provide report on his work activity for some times, it is possible for the employer to discipline the employee, and in the worst case scenario to terminate the employment agreement. But this will not be possible anymore according to the draft law, and only the termination grounds which are currently provided by the Labour Code for ordinary employees will be possible. And why does it raise a lot of concern is that we know in practice, actually, that for distant workers, some of the termination grounds which are provided for ordinary employees are not applicable, meaning absenteeism and alcohol intoxication. In practice, it is impossible to sanction or to terminate an employment agreement with a distant employee since, and I will not expand on this considering the time frame we have, but for example, since according to the Constitution, your private home is inviolable. Hopefully I'm not Englify a French word, but according to the Constitution, no one is entitled to enter your private home. The same, let's imagine that your head office is in Moscow and your distant worker is located in Vladivostok. If during a webinar or a Skype conference, it appears that, or it looks like your employee is maybe under some alcohol intoxication, the time for you to go there and the effect will have disappeared. So in practice, these two grounds for termination of employment agreement are not applicable, and even there are some amendments which are proposed to this draft law to mention that actually alcohol intoxication and absenteeism will be excluded in relation to distant/remote worker. So another thing which I'd like to mention, and which is considered by specialists as a shortcoming or controversial points in this draft law, is that the draft law does not give possibility so far for the employer to call the employee to the office. So how does it work if, for example, the employee has to go to the office for urgent need? Another issue, according to the current draft, if the employer contacts its employee after working hours, so during the rest time of the employee, this will be considered as overtime as far as the contact or the request is labor related. So what will happen if, for example, you need to contact your remote worker or your distant/remote worker for an urgent issue? And worse, what will happen if actually the employee takes the initiative to call its employer after his working hours? So should this be considered as well overtime work? So as we can see, there are still, despite the fact that the draft law made some progress into legalization of remote work mode, there are still a lot of issues to be considered and to be discussed, and hopefully during the next two readings of the law, amendments and related amendments will be made so that actually this draft law become a real tool and a safe tool for employers to install and implement remote work, so far distant/remote work. So now I will pass once again the word to Katia, who will be talking about workplace safety. Katia?
Yes, workplace safety is quite an important topic for distant and remote work. For distant employees, regulations are very beneficial, I would say, for employers because they are relieved from the majority of work safety obligations in relation to distant workers who have this distant work employment agreements formalized as per Russian labor code. For such employees, you need only to fulfill these 4 listed obligations, including job accidents investigation and payment of mandatory social insurance for occupational safety, but such insurance is paid in relation to all employees, so there is nothing in addition. For remote workers, for example, if you have a combined regime when employee works from the office and from home on some days, the current legal situation is difficult, I would say, because such remote workers is considered as regular employees in terms of workplace safety obligations, and employers must fulfill all obligations envisaged by labor code, including, for example, special assessment of working places, which can be difficult or even impossible to fulfill for remote workplace location, because to conduct this special assessment, you need to hire an organization whose experts will shall come to workplace and measure various factors like level of noise or lighting and things like that. And as you can imagine, that it can be impossible to do at the employee's apartment because the employee may just refuse, or maybe like apartment may be located far away from your office. That is why currently when employers introduce this remote work that is not envisaged by the labor code, they accept certain risks related to labor safety, and in case any job accident happens, then employer may be liable for non-fulfillment of work safety obligations as they are provided by the labor code. But we hope that this situation will be resolved by the bill Christophe described just now, because the draft law proposes that when employee works remotely from outside of the employer's premises, employer will be obliged only for a limited number of obligations and not to the full scope as currently for remote workers. So now we proceed with the poll.
Yes.
Now we will please answer certain questions on monitoring employers or employees' activity, and we will proceed with further slides of our webinar.
Could we have the result, please? So, interesting actually. 54% of the actually attendees are not monitoring the employee work discipline, whereas 46% are doing so. So more or less it's half and half. Interesting. Interesting because actually one of the main difficulties for employers sending people to distant remote work, and if you don't mind, I will just use remote work so for the next minutes, is of course to monitor the activity and the performance by the employee sent to remote work of her labor duties. What must be mentioned is that currently in Currently in the labor code, with regard to distant employees, the labor code provides for the fact that the employment agreement must contain actually the procedure and term for submission on reports on the work performed by the distant worker, as well as the work regime, meaning at which time the employee is working, which time the employee is resting. So which allows the employer to monitor this activity. So this is provided by currently by the labor code on distant employment. But with regard to remote work, and until we have clear and legal definition of such a regime, so far it is very difficult for the employer to monitor the activity, and this is why we strongly recommend the employers to provide either or even end in the employment agreement or addendum to the employment agreement on transferring the employee to remote work, and in the local normative act, internal regulation, the following in order to ensure possible monitoring. So first of all, what we strongly recommend is to provide for the working time regime, or at least, if it's not possible, the core time bands during which the employee is obliged to be working, or at least to be available. The second point is to provide the ways, form, and periodicity of exchanging information between the employee and the employer. Then third item is to provide for specific time for a remote worker to perform some particular duties. For example, we have seen the case for an accountant to make sure that the deadline will be respected, that and that the rest of the financial department will be working properly. We have provided in the addendum of the employment agreement on transferring this employee to remote mode an agenda, if I can say so, of her activity to make sure that it will not impair the work of other colleagues. And to provide as well the obligation for the employee to respond to calls, requests, or any emails of the employer, and as well the period of time during which the employee has to do so. If, for example, we are talking about combined work, to provide as well the days where the employee has to be in the office and the one when the employees stay at home. But if it is very impossible to specify once for good these days, you need to provide at least for the approval procedure of such calendar. Then another important feature is to provide for the obligation of the employee to use the equipment, IT system, IT programs, hardware, software of the employer, or at least the one which are recommended by the employer. This is especially for security measures and confidentiality measures to avoid an employee to use its personal computer or personal hardware, and where you may have not control over the security program which have been installed. Another obligation is to ask the employee to be logged onto the systems, the one with the IT system, during working hours. And another important feature is to mention that the employer is entitled to check actually at what time and when the employee access to the IT system, and maybe to by the use of some geolocation tracking system or review of the corporate mobile phone bill, to analyze the activity of the employee. So, of course, this list of obligations and recommendations are best practice, but is not exhaustive. And depending on the particularity of the activity of an employee, it is possible to expand or complete this list. And so that you have some tools. And so just to conclude that if you not do so, it may have very negative consequences, since if you do not provide, for example, for the obligation of the employee to respond to a request in a certain period of time, if it does not do so, it will be very difficult to make him liable for lacking and for not answering in due time. And as a last item, I will give back the words to Katia, and actually she will answer one of the questions, which is, could you please kindly clarify if a compensation for the usage of personal assets in the company interest? So Katia will mention about reimbursement of expenses and therefore answer this question. Thank you.
Yes, as you can see, reimbursement of expenses, we have this slide combined for both distant and remote work because the same rules apply to both situations. Well, first of all, what you need to compensate to the employee are expenses related to business travel. For example, if you ask your distant employee to come to the office and this is considered as a business trip, therefore, you need to compensate such employee usual business travel expenses for transportation, accommodation, pay per diem to the employee. In case employee can return to home same day, then you don't need to pay for accommodation, obviously, and also don't need to pay the employee per diem, because per diem is paid only if employee stays away from his or her house for more than 1 day. Also, another compensation that should be paid is compensation for use of private property of the employee for business needs. The most obvious example is the use of private car for business travel. In case employee uses private car with knowledge of the employer or with approval of the employer, then employer should pay employee compensation for wear of the car, and also compensation related to use of it, well, like petrol expenses. If you need to pay this compensation, it should be fixed by employment agreement. Also, please provide in the employment agreement all details, how it is calculated, which documents employee should provide in order to be paid compensation, to confirm, for example, that petrol expenses are related to business travel and not just private trips of your employee. Another issue is other expenses related to distant work, like cost of internet connection or mobile services if you don't provide employee with a corporate mobile phone. The labor code in respect to distant employees, it says that employment agreement can provide for compensation of these expenses. Previous opinion of the labor authorities was that if employee uses his home internet connection for business purposes, you need to pay this compensation. They were quite firm in that. But recently, they started to change their mind, and there are various clarifications of State Labor Inspectorate saying that in case you don't have any provision in employment contract on payment of compensation for internet or for mobile services, then you don't need to pay this compensation to employees. So currently there is no clarity if it should be paid or not. In our opinion, the safest approach would be to include some reasonable compensation in the employment agreement, because it allows you to avoid disputes with employees in case you have a conflict situation and employees starting to claim various things. If you have this compensation fixed by the agreement, this minimizes your risk. What I can add, if you decide to pay this compensation, please bear in mind that, for example, if employee pays for internet connection, he or she uses only approximately 8 hours per day for business needs, and other part is private use of the employee. So you need to calculate this compensation proportionally to the time employee uses his private internet connection for business needs. So I think this is all we wanted to discuss with you today. And I pass word to Christoph, who will do a wrap up of our webinar.
Yeah, thank you, Katya. So as we have seen, currently the Russian legislation does not provide for remote work as such, and its implementation over the last few months by employers has been empirical. But fortunately, we do hope that the draft law will be passed during the fall session of the Duma, and which will provide some security and legal comfort to the employers in when resorting to remote work, which obviously shall be the case if the situation continues, unfortunately, to damage. This is the end of our webinar, and now Katya and myself will be very pleased to answer your questions. And I see one already, which I will be reading. Can we combine a private property usage reimbursement and home internet for remote worker in one compensation?
Well, let me answer this question. I think that for tax purposes, it's better to divide them to two compensations, or at least to provide, if you decide to make it as a one compensation, to insert in your addendum to labor agreement documents which proportion is compensation for usage of private property and which part is compensation for remote workers for internet connection. So I think it is better to divide them to two compensations, but you can do in one. But at least in your documents provide which part of compensation is for what.
Mm-hmm. Thank you, Katya. I have another question, which I would say is not strictly legal and maybe a little bit more psychological, as to how do Russian employees react to remote work, or what is their feeling? So, well, we are not psychologist or specialist in this, but what I can tell you is that I recently read survey from Rostrud, according to which actually a little bit more than, if my recollection is right, more than 21% of the respondent considered that working from home or in remote work has more disadvantage, than advantages, and this is due to the fact that family members can be disrupted. This is due as well to the fact that we are losing contact with people, with our colleagues. Due to the fact as well that it has been noted that the continuation of the working day lasts much longer than when you are in the office, because when your computer is on a permanent basis switched on at your place, you have a tendency to sit and look, despite the fact that it's 9 or 10 o'clock. At least this is, I know that this is the case with Katya. But what I noticed as well, and what I read as well and remember, it was that for some, but actually quite a considerable number of respondents, some considered that remote work is good because you didn't have to participate to the office life, if I can say so, and you avoid the gossips, which I found quite surprising, but and this is why I remember this. So these are more or less what I remember about this question. Another question: are COVID tests still mandatory for employees each 15 days for 10% of employees? The answer is yes. This has not been changed. That's for sure. And I'm very sensitive about COVID test because I just came back from abroad last week, and first of all, to come back, it has been a nightmare, and I had to have these 3 times this COVID test translated into English and things like that. And when you are in a small city in France, that was not easy to obtain. Another question: is it mandatory to draft employment contract addendum in Russian? Yes, of course. And or is it fine to have it in English? Only the employee understands English and uses to perform professional duties. Well, at least, and Katya, you may complete, for sure it must be in Russian first, but when with foreign employees, it can be in Russian and then in her national language, in bilingual form, but Russian is compulsory. Russian language, sorry.
Yeah, I agree, and the most common approach, I think, to have it Russian English version, even for Russian employees, because foreign managers, for example, could be non-Russian speakers. So normally you have it bilingual. But what is important, Russian language will prevail even if you have it bilingual.
I don't see any more questions. So since we have reached our 45 minutes presentation, so once again, I would like to thank all of you for your attendance. We hope, Katya and myself, that you find this webinar very interesting, knowing that this is a very hot topic in Russia. And we hope actually to be able to renew this webinar once the draft law will be passed and once we will have more concrete items to be discussed when reading this final law introducing temporary remote work. So thank you very much, and have a nice end of the day. Bye-bye.